Thanks for staying with us here on Eye on Ocean County. I'm Christina Seco. Do you have someone you can trust who can legally act on your behalf in the event of illness, disability, or absence? As Bob Novy of Novy and Associates tells us, it's a good idea to name a power of attorney if you haven't done so already. Thanks again for being with us, Bob. Enabling someone to act on your behalf. It sounds easy enough, but not everybody does so.
Correct. Power of attorney, Christina, is a way of saying, in the event I need help, whether I'm disabled or, as you mentioned at the outset, if you're absent, if you're on vacation or just not available, it's someone you trust to handle your personal and your financial affairs. It can be someone who you want to simply pay bills, have access to your checking account, to be able to go into your safe deposit box. Or it could be someone who can do all of that and also arrange for caregivers to bring people into your home to care for you if the need arises. Or it could be someone who may have to sell your home if you become disabled and you can't safely stay at home in the future and you need to perhaps transition or relocate to an assisted living facility or a nursing home. It could be any or all of the above circumstances, depending upon what the client's goals and objectives are.
Now, can a person revoke that authority that they've given if they need to do so?
Absolutely. They can revoke it by simply tearing up the document. They can advise the individual they name that they no longer have the power, or perhaps the individual, the client in this case, may have made a new document, may have named a new power of attorney. But I would normally recommend that not only that they advise that individual that they're no longer named, but a letter should go out to the individual. And in certain circumstances, if they have any doubt or fear that the person may continue to use it or act inappropriately, the client can also notify any financial institution that the power of attorney has been revoked, so the person who they named can no longer act intentionally or unintentionally if the person didn't want them to have that power and responsibility.
So it sounds like this is something that needs to be done in advance in the event that you do need this situation, because it sounds like maybe if you do it when you need it, it may be too late.
Absolutely, because if you need it, for example, if you should be the victim of a stroke, dementia, Parkinson's, a bad accident, a broken hip, or something like that, the question would be, that's a heck of a time to have to get your legal affairs in order. And what if you don't have the mental ability to sign the document? Or what if you're confused and you're not sure who to name and what authority do you want to give them? And that's only part of it. Signing the document is part one, but the other part is to have a set of instructions available so the person you're relying on and counting on and wish to give this power to will know what you own and where it's located. So it's a twofold process: preparing the document and having a good checklist filled out in advance so that the person you're relying on, in the event that you need them, in the event of a disability or in the event of your absence, as you mentioned earlier, someone knows they're named and what they can and can't do and how they can do their job best for your protection, especially in the event of disability.
Okay, and there's different types of powers of attorney, one being a durable power of attorney. What does that mean? Durable,
Christina, means the person you name you trust fully and you're comfortable with them having the authority to act literally at any time, today, tomorrow, next week. Even if you're not disabled, you simply want them to have the ability to act literally at a moment's notice. The alternate to that is a limited power, and limited typically means they don't have the authority to act today or tomorrow, but rather only in the future, only if you either request their help in writing or if you are truly disabled, which would normally require a doctor to examine the person and sign a letter saying, due to whatever medical problems they're suffering from, they're not able to handle their personal and financial affairs. And then and only then can the person you name act on your behalf with that power of attorney.
Okay, so they need written consent from a doctor prior to doing so.
Correct. Unless the client himself or herself has signed a letter saying, this is a limited power, but I authorize you to act now, even though I may not be disabled.
Now, naming these powers of attorney, is this something that they, a person can do when they're filling out their will, when they're obtaining a will?
They can. The difference is, Christina, a will acts only in the future upon the death of the person. The power of attorney is something that can be used while they're alive in the event that they need that assistance during their lifetime. And that's correct. That's something that the attorney would normally talk with the client about, having both documents at the same time.
And speaking of wills, how important is it to have a living will?
A living will is an adjunct to the power of attorney, and I'm glad you reminded me to bring that up. The living will is where you're saying, in the event of end-of-life issues, heroic measures have to be decided upon. This is who I trust to carry out my wishes, and these are the specific instructions I want you to follow in terms of if I'm not able to answer these questions myself, whether or not I want to be resuscitated. If I'm brain dead, do I want to be kept alive? Do I want fluid and food provided? And a whole host of other medical questions that have to be decided upon. And as a matter of fact, Christina, anytime a client goes to the hospital, even for outpatient tests or same-day surgery, the two questions and the two forms the hospital will ask for is their health insurance or Medicare card, and do they have an advance directive or living will. And it's good when you go to the hospital, and if you have a regular doctor, to make sure that your doctor has a copy of your living will, and that it is a document that your family members and or close trusted advisors should be aware of and have a copy of as well. I wouldn't recommend that you give a copy of your will to your family because they don't need to see what's in it now, and you don't want to create that kind of a controversy for yourself where people are going to judge and question who's getting what and why shouldn't they get it all. But if you have somebody named as power of attorney, if you have someone named on a living will, they should know you've done this, and they should either have a copy or know where the documents can be located. And one last point I want to mention, if I may, on that in that regard is that you should not just name one person as executor of your will or one person as power of attorney or one person on a living will. You should always have backups or alternates in case the first person either dies, becomes disabled, or is simply not available.
Now you mentioned you don't have to show it to your family members. Now, usually I would think that most people would name their spouse as, you know, the executor or whatnot. Now, if you do indeed die without having a will, would everything automatically just go to your spouse, or does
Typically, under the laws of intestacy, in most cases, yes. But if there are children of other marriages, they may get a piece of the estate. If there are children from multiple marriages, they may all share, depending upon whether the children are born to the client who died or not. Stepchildren may or may not take from the estate if the person dies without a will. So again, why leave things like that to chance? The laws of intestacy can be very complicated. So why should we assume that everything is going to go a certain way when in fact it may not?
Okay, and last question for you. Guardianship. Why is this so important, and who will make these important decisions if indeed you become incapacitated?
Well, if a person is incapacitated and doesn't have the advance directive living will and doesn't have the financial power of attorney, the court will, but somebody's incapacitated or not able to act on their behalf, someone may have to bring an action in court known as a guardianship, which means a complaint, an order to show cause is filed in the courts. The court will appoint a second attorney to represent the interest of the alleged incapacitated person, and then the court's going to decide A, whether the person is able to act or needs a guardian, and B, who should that guardian be. It's expensive, it's time consuming, and frankly, it's a loss of privacy. So rather than have all that dragged through the courts with much delay and expense, a person can designate someone that they select, that they trust to act on their behalf now or in the future if they really need that kind of protection.
Okay, Bob, thank you so much. We have to take a quick commercial break, but don't go away. We have more to talk about with Bob from Novy and Associates when we come back. Thanks for staying with us here on Eye on Ocean County. I'm Christina Seco, and joining me once again is elder law attorney Robert Novy of Novy and Associates. And let's talk a little bit about probate and what that means. I know it's a term lots of people hear, but they may not really understand what it does for them.
Christina, probate means to offer the will for proof. To present the will typically at the surrogate's court, the executor appears with the original will and a death certificate. The will is filed, which is what probate means. It becomes a public document. And then the executor then has the ability, they get paperwork from the court, which allows them to collect the assets, to open up the necessary accounts, to pay bills, and to handle the administration and the ultimate settlement of the estate.
So some people think that by setting up a trust that it'll automatically allow a beneficiary to receive their inheritance right away, but that's not always the case.
No, it's not, because whether the estate's settled by a will, which is what probate is all about, or whether the estate is settled through a trust agreement, in order to avoid the step of probate, and there's a lot of myths and misconceptions about that, the executor of the estate or the trustee of the trust still has to follow certain requirements. They have to pay bills, they have to pay expenses of last illness, funeral bills, and so forth. And then depending upon what the estate includes or consists of, they typically have to file final income tax returns, possibly state and or federal death tax returns. So a revocable trust, while it may eliminate the need to probate or file the will in a courthouse, it doesn't lessen the responsibilities of what has to be done to settle the estate, and whether or not there'll be a tax due really depends upon the size of the estate and who the beneficiaries are going to be who are named to receive everything.
So what are some of the advantages of having such a trust, and why do you think some people think that they have to avoid probate?
Well, avoid probate, when you hear those words, it sounds like an illness I got to avoid, and you really don't. But where a trust does make sense is sometimes in the case of a second marriage, sometimes if a person has disabilities and they want to have a plan in place where they actually put assets in a trust now, so in the event of their illness, disability, or death, there's a continuity, especially in the case of a surviving spouse, or if they have a disabled child or a disabled heir they wish to protect, especially if that person is getting certain state or federal aid, such as SSI or other benefits, or if they're leaving assets to a person that may be in a nursing home, or if they're worried themselves about going to a nursing home. They may want to protect some of their assets from what's known as a spend down or Medicaid. Or if they have real estate here in New Jersey, but they may have a second home in Florida or some other state, and they want to avoid the expense and the delay of having to probate or file their will in multiple states. That's where a revocable trust may be used, so that they don't have to file the will in each state where they have that real estate.
Okay.
And the revocable trust can do that.
Okay. Does it take a long time for a beneficiary to indeed get their inheritance if they, when they have probate?
Not really. It really, again, depends upon what the size of the estate is and whether there's any tax liability. For example, in New Jersey, for spouses, there's no inheritance tax or no federal tax. For children, grandchildren, stepchildren, there's one exemption for the whole group or family, and that's $675,000. So if the estate's below that amount, and we're talking about close family members, and we're not waiting for any tax clearance from the state of New Jersey, for example, the estate might be settled within 3 to 6 months, depending upon what the assets are, depending upon if there's a house to sell and how long it might take to sell the house. Now, if the estate is going to more distant family members, such as brothers and sisters, nieces or nephews, then there would be a tax to pay to the state. And if the estate is over a certain size, there may be a federal tax as well. So whether or not there's a tax and who gets the estate will really determine how long it takes to settle, because when we have those tax situations in place, Christina, we have to get clearance from the state and or federal government.
Okay, Bob, I want to talk about your firm for a little bit. You do have an office in Manchester and then one in Seagirt. And when you hear the term elder attorney, I would think that elderly clients, I mean, does that deter people that are younger from using you, or how does that work?
Well, elder law really refers to people that are aging in place and want to protect their assets and protect their lasting legacy to make sure it's orderly distributed to the next generation down the road. But not everyone to see an attorney or an elder law attorney needs to be elderly. As we mentioned at the outset, anyone over the age of 18 should consider having a will. Anyone over that age should consider a living will or advance directive. And of course, anyone over that age should consider a financial power of attorney as well. The first case that I think of with regard to living wills was Karen Quinlan, who I believe was about 21 or so years old when she suffered from a vegetative state and wound up in a coma, and her family had to go to court to have the right to dignity and recognize the right to die without life support. And that's what led to what we now know as advanced directives and living wills, both in New Jersey and around the country for that matter. So that's a situation where a younger individual had an unexpected illness. Another case out of Florida, Terry Schiavo, a fairly young woman, So these are situations that motivate us to have our legal affairs in order regardless of age.
Okay, and you also have a show, Inside the Law, every Saturday from 10 to 11 on 1160 WOBM AM. You've been doing this for 16 years. People can call in. What can you tell us about that show quickly?
We're on every other Saturday on 1160 WOBM AM and 1310 AM every other Saturday morning. And if they check our website, which I know is being featured on our broadcast this morning, they can see when our next broadcast will be.
Okay, and I hope people can tune in. Of course, you said every other Saturday. And for more information, you can log on to novylaw.com. And we'll see you next time on Eye on Ocean County.